5 seconds to go. Start. By the Finance Act 2013, Act 17 of 2013, Section 40 of the Act is amended by inserting Section 40A2B, which has come into force from 1st April 2014. The said provision under Section 40A2B reads as under: notwithstanding anything contrary in Sections 30 to 38, the following amounts shall not be deducted in computing the income chargeable under the head profits and gains of business or profession. Nothing an authority, a board or an institution or a body established or constituted by or under any act of the state government or owned or controlled by the state government, while it is the case of the assessee appellant that the gallonage fees, license fee and shop rental for FL9 license and FL1 license, the surcharge on sales tax and turnover tax do not fall within the purview of the above said amended section. The case of the revenue is that all the aforesaid amounts are covered under section 48(2)(b). As such amounts are not deductible for the purpose of computation of income for the assessment years 2014-2015 and 2015-2016. During the assessment years 2014-2015 and 2015-2016, the appellant was holding FL9 and FL1 licenses to deal in wholesale and retail of Indian made foreign liquor and foreign made foreign liquor granted by the Excise Department. FL9 license was issued to deal in wholesale liquor which they were selling to license holders. The FL1 license was for sale of foreign liquor in sealed bottles without privilege of consumption within the premises. The gallonage fee is payable as per section 18A of the Kerala Abkari Act and Rule 15A of the Foreign Liquor Rules. The appellant was the only license holder for the relevant years so far as FL9 license to deal in wholesale, and so far as FL1 licenses are concerned, it was also granted to one other state owned undertaking, that is Kerala State Cooperatives Consumers Federation Limited. By interpreting the word exclusively as worded in section 48(2)(b)(a) of the Act, High Court in the impugned order has held that the levy of gallonage fee, license fee and shop rental with respect to FL9 licenses granted to the appellant will clearly fall within the purview of section 48(2)(b) of the Act, and the amounts paid in this regard is liable to be disallowed. At the same time, the amount of gallonage fee, license fee and shop rental paid with respect to FL1 licenses granted in favor of the appellant for retail business, the High Court has held that it is not an exclusive levy, as such disallowance made with respect to the same cannot be sustained. With regard to surcharge on sales tax and turnover tax, it is held that same is not a fee or charge within the meaning of section 48(2)(b). As such, same is not an amount which can be disallowed under the said provision. Shri Ganesh, learned senior counsel appearing for the appellant, by referring to explanatory note to the Finance Act 2013 and section 48(2)(b) of the Act, had submitted that the levy of gallonage fees, license fee and shop rental on FL9 license is not on any state government undertaking, but same is a levy on the licensee. It is submitted that the levy was on the license holder, whoever he or it might be, and only in view of the abkari policy of the relevant years, licenses were granted to the appellant. As such, it cannot be said that same was exclusive levy on the appellant, attracting section 48 2b of the Act so as to disallow the same. It is submitted that the mere fact that in a particular year the license holder happens to be state government undertaking does not make the levy one which is imposed directly and exclusively on the state government undertaking. It is submitted that High Court has failed to appreciate that the decision as to whom FL9 licenses are to be granted depends only on the state government's abkari policy, which may vary from year to year. It is submitted that said submission also holds good with regard to gallonage fee, license fee and shop rental for FL1 license, which issue is already decided in favor of appellant by the High Court. Stop.